call our file against her.
Criminal case number 63 of 2026, Uganda versus Dr Linah Zedriga.
This is my ruling. It is the constitutional right of every accused person to apply for bail. This is clearly stated in Article 23, Sub-Article 6, Paragraph A of the 1925 Constitution as amended. Whereas it is the right of every accused person to apply for bail, grant of bail is not automatic, it is discretionary. However, in exercising the discretion, judicial officers must do so judiciously. These inter alia include: must not be biased and should not reject bail for no good reason. In any case, releasing an accused person on bail does not amount to acquittal. It is a mere temporary release of an accused person to attend court while coming from home as opposed to from prison. In the instant case, the charge preferred against the accused person is triable by this court. Therefore, this court is clothed with the jurisdiction to entertain this bail application. The applicant availed for sureties. However, prosecution vehemently opposed the bail application mainly on grounds of substantiality of the sureties. The Land State Attorney submitted that the first and the fourth sureties are friends and colleagues to the applicant or the accused person. The applicant is charged with offense of incitement to violence. She argued that by the very nature of the offense, there is high likelihood that the friends and colleagues share the same ideology that led to the same offense, and as such, they are less likely to act as messengers or officers of court. That further, as friends and colleagues of the applicant, they may not be able to execute their duties as sureties diligently. I have addressed my mind to the particulars of the first and the fourth sureties. I have also addressed my mind to the rejoinder by the Land Council, specifically Council Haddad Salim, to the objection raised by the State Attorney in regard to the first and the fourth sureties. First and foremost, I would like to state categorically clear that to be a friend or a colleague to an accused person is not a bar or an impediment to be a surety. The most important question is whether or not the surety will be able to execute his or her duties as a surety. The Land State Attorney submitted that the two friends or colleagues have got no superior authority over the applicant. I have carefully considered the State Attorney's submission on this point, but found nowhere in her submission the position held by the applicant and that of the two sureties that has made the applicant in superior position to the first and fourth surety. Secondly, to say that this bail application should be rejected because the nature of the offense preferred against the accused involved violence, and by the nature of the offense, there is high probability that the friends and the colleagues share the same ideology is presumptuous, far-fetched, and with no concrete base, and it defeats the fundamental principle of presumption of innocence of an accused person who has pleaded not guilty to the charge preferred against her. All in all, I have considered the particulars of the first and the fourth sureties. I found the two are substantial upon perusing their introduction documents and their identification documents. So the first and fourth sureties are substantial. Turning to the second and third sureties, the state attorney, in objecting their suitability, submitted that one is a niece and the other is a cousin to the applicant. And based on this relationship, they cannot exercise superior control over the applicant. With due respect to the objection raised, I found the objection is not known in the legal corridors. A niece or cousin cannot be sureties, and or are not fit to be sureties is unheard of in the legal circles. I also would like to point out that a formal introduction letter from the diocesan bishop or mother superior of the congregation is not a prerequisite to consider a reverend father or reverend sister to be a surety. However, it is an added advantage. Lastly, the fear that tomorrow they may be transferred and therefore will be hard to trace holds equally no water, because when a priest or a reverend sister is transferred, they are transferred to a specific location with known address. Therefore, the fear placed by the prosecution that they may not easily be traced is far-fetched. Having considered the particulars of the second and the third sureties, I also found them substantial. The accused is a person of advanced age. She's 64 years old, and has availed to this court 4 substantial sureties. As I did state earlier on, bail should not be rejected unless for a good reason. State has not objected to the documents availed by the accused persons, therefore they are taken to be authentic. All in all, I know no reason sufficient to reject this bail application. I allow the bail application on the following conditions. 1, the accused person deposits cash bail of Uganda shillings 1 million. 2, each of the sureties are bonded Uganda shillings 10 million, but not cash. I so rule. The next date for, give me that diary. Check what it is. Today is 14th, not 24th. This matter is adjourned to 24th of March. The accused person is further remanded till the bail condition is fulfilled. You are waiting for the last word.
All right. Okay.